The Electoral Commission's declaration of the 2012 election results that pronounced President John Mahama winner of the elections has been disputed by the new Patriotic Party. The party is seeking the annulment of over 10,000 votes, citing irregularities, malpractices and omissions as basis for the cancellation. The results declared by the Electoral Commission therefore ought to be set aside, and the flagbearer Addo Dankwa Akufo pronounced winner of the election. This set the tone for the election petition hearing at the Supreme Court some 7 months ago.
And malpractices in the 2012 elections saw the opening of a new chapter in the history of the Supreme Court regarding the hearing of an election petition case. Since hearing officially began on April 16th, the petitioners who filed documents at the court as evidence to establish their case sought to prove that the declaration of the result did not reflect the votes counted. The respondents in the case also sought to prove that the petitioners' claim of irregularities have been exaggerated, and the statement of poll and declaration results sheets, which have also come to be known as the pink sheets, have been padded. It's been a battle of evidence, with counsel from all sides cross-examining and re-examining witnesses to establish one point or the other. Objections were raised on several occasions by counsel to dispute one line of questioning or the other in the course of cross-examination. There were also instances when counsel had to be cautioned by the court on their choice of language, especially when tempers seemed to rise.
These long lectures that we are submitted to every now and again and insults are totally unnecessary. All we are seeking to show the witness, he himself has said that there is A and B, and we are showing him these documents. These are pink sheets that have been served on the respondents since April. They're supposed to be familiar with them. Why do you get up today and try to give the impression we are manufacturing pink sheets at the last day?
There is no commissioner of oath stamp on this document, my lord.
You continue to be learned friends even after this case, and we have rules of the game, and we have repeatedly advised that it's not advisable to go contrary to our rules of etiquette. It's not for nothing that we are called learned profession. Please, let's maintain the decency and decorum that is required of us, especially in the highest court of the land. It is very important. The message you send out here is the message that the grassroots supporters of your political parties will pick. So it is very important for you to set the standard, and then they will follow suit.
On occasion, the Supreme Court had cause to stamp its authority to rein in those engaged in contemptuous commentary in the media on proceedings calculated to prejudice the outcome or impugn the integrity of the panel of judges. On the whole, the process has been applauded by many as a bold step in the country's political history.
This is the first time such a petition is being fought. We have had to look at our own laws. The law regarding procedure is very limited, so the court itself has had, where it is not so detailed, to fall back on its own Supreme Court rules, or alternatively on the High Court civil procedure rules. We have also had to fall on other jurisdictions where they have gone through the process.
It's been tough for us and for all of us, because this is a unique case and we've all gone through it together. So personally, I would say congratulations to the media.
On the final day of lead counsel for the petitioners, Mr. Philip Addison's cross-examination of witness for second respondent, Dr. Kudwa Farijan, the atmosphere in the courtroom clearly indicated that counsel from both sides are indeed learned friends of the bar. The major hurdle has been crossed, but it is not over yet. The court has ordered that the respective parties prepare summaries of their case supported by analysis of the mounting of evidence at their disposal. These will be put in addresses to be presented before the court on the 31st of July. If the court's orders are complied with, a date will be set for the verdict.